EGM Network.
Hi, welcome to Silver Linings. I am one of your hosts. I am Janean Barrows, and my friend and partner over here, Raul Perez.
Hello, everybody.
And we are revisiting a topic that we started discussing a few months ago. And today we're lucky because in the studio joining us for the second half of that topic is Susan Chesnutt. She is a local family attorney here in Indian River County for many years, a child advocate well known in our community. And she's going to kind of pick up where we left off a few months ago. And we are going to talk about adoption, dependency, when parental rights can be removed, and why is there a certain process and why it's important to understand the different steps of that process today. Thank you. Thank you for coming back.
Thank you so much for having me back. And as much as I liked talking about the other types of adoptions, this is where my heart and soul lies. Within the dependency system, which is, for those listening, that's where the child abuse court takes place. It's called dependency.
Okay. All right. So most of us wouldn't know that, right?
No, and I try not to use the term dependency. When people ask me what I specialize in, I usually say child abuse because nobody knows what dependency means. But it is its own area of law. It's under Chapter 39. It has to do with the Department of Children and Families and their ability to intervene and try to keep children safe. And that's where...
So
that's where I live.
Unique niche within the system.
It is. Very few attorneys are familiar with Chapter 39 to the extent that they have done litigation or participated in the processes all the way through up and until the adoption application review committee and challenging those types of things.
Yeah, Raul was saying to that effect, I mean, obviously there are specialized fields of law and, you know, his firm specific to having a focus on senior law and geriatric law, but he was even highlighting the fact that law is not the same across the board.
It is absolutely
and
not.
that you want somebody who specializes in the field you're seeking.
Right. And even in family law in general, this would be a subsection of family law overall. And there's a lot of different aspects. And obviously, I am not an expert at that. Someone like Susan is, who can tell us a little bit more about dependency and how, you know, that's different from the private adoption, which we talked about last time.
Yeah, credentialing is important. It's not just across the board the same.
It's not. And I will say, just to note, that most family attorneys do not practice dependency law because it is very specific, very procedurally, you know, regimented. You
better know.
Yes,
what
it is not the same
through.
thing as family law. But because I am so, you know, passionate about families, this is my niche.
Well, lucky for us in the community.
Thank you.
That we have you.
So tell us, I mean, I think we brushed upon it a little bit, but what are the differences between dependency and private adoption?
So you can do private adoption with independency. They advise you as soon as you enter the system as a parent and your child has been removed and placed in an alternative placement that you have the right to seek a private adoption at any point. But the difference is that because the state of Florida is acting in loco parentis, I think that's how you say it, they're acting as the parent of the child, their regulations and their procedures, and there's just so much more bureaucracy within that type of adoption than there would be in a, as you say, private adoption. So private adoptions are under Chapter 63, and these dependency adoptions are under Chapter 39. So you do have the ability to adopt within Chapter 39, but then you also have the ability, if you're successful in an intervention, to adopt it under Chapter 63, which is where this all gets very complicated.
I'm already like, what?
Yes.
Ooh, where?
So there's two different adoption statutes. DCF, because they do terminations of parental rights, they do their own adoptions within their dependency court. Whereas Chapter 63 adoptions are what we talked about last time, all the general adoptions as well. But it also includes dependency by a private person who is intervening into the dependency process. And we'll talk about what an intervention is later.
So can you say for the listeners in clarity, you know, you're saying DPT. So what does that mean?
What?
When you were saying you were calling it an anagram, forgive me, and you were talking about the dependency, and you were talking about removing the parental TPR.
I'm sorry.
What
Yes.
does TPR stand for?
TPR stands for termination of parental rights. So let me back up. When a child is taken into custody by the department for abuse, abandonment, and neglect, it's often done, call to the hotline. The hotline is located in Tallahassee. It's a 1-800 number. Depending on how old the child is or their specific allegations, they either get a 24-hour or an immediate response. They go out. The child abuse investigator gets assigned to the county where the child is located. Okay. They go out. They do a safety assessment. If they can't plan to secure the child's safety through some sort of contract between the parents that this or that won't occur, or we'll have additional relatives come stay and assist and things like that, then they're forced to effectuate what we call a shelter or a removal, and where they take the children from the parents into the custody of the state of Florida. And then within 24 hours of that taking, there is a court hearing on the probable cause for that taking. It's a very low burden, and it's called a shelter hearing.
So that's going to usually be a first step once there's a situation
101.
Identified.
That's
so this is the first aspect of somebody calls in and they're saying, hey, I've got a concern with a child's safety. Maybe this is a teacher or a different social worker, or maybe even an aunt or an uncle calling in, or a neighbor, right? Mm-hmm. And so that creates this note, and they're going to be assigning a case manager that's then going to go out and investigate.
They assign an investigator who investigates.
Okay, now, so the difference between case manager
and
investigator.
And so
right?
A case manager is once the child has entered the system and passes from investigations is only there to assess the risk, do what they can to alleviate that risk, and if it's not possible, then they effectuate the removal, right? They offer services and things like that sometimes.
Sure, the goal would be to make a safe space.
The goal is always to try to leave the child in the home, but that's just not possible sometimes. Sometimes parents are incarcerated. Sometimes parents are in a mental health facility or substance abuse facility. There's all kinds of reasons. And then once the case has reached a certain point, the family is passed on to someone that maintains contact with them on a monthly, regular basis while the investigation gets closed. Then it gets handed to someone who works with that family one-on-one throughout the entire remainder of the process. Okay. That's a case manager. They're the ones who do the home visits, make sure that you're doing your services on time, notify you of court, if there's drug screens, request your screens, make referrals for services, all of those types of things.
Okay.
So I think you got to the point where you were talking about if there is some type of issue, then there would be some type of court hearing possibly.
Yes.
Shelter hearing, I think you called it. Mm-hmm. Now, let's say that a shelter hearing is heard and the judge determines that for the safety of the child, he has to be removed. Where does that child normally go?
I appreciate your question, because this is going to lead us where we need to go with the rest of this conversation, because I have determined through my experience now engaging in this practice of law for such a long time, timing is everything. When the investigators go out, part of their responsibility when they do a removal is to ask the family for alternative placements for family members, friends, anyone who has a relationship with the child and is willing to take the child. If there's more than one child, the goal is to keep the children together, which often complicates things as well. But they do an inquiry. Most of the time, though, I find the inquiry is, do you have anybody available that you think might be able to take your child? Well, what do you mean? Does that mean here? Does that mean in a different state? Does that mean in a different county? Does that mean...
Creates new questions.
And they don't really know. So most people are so caught off guard. And in their mind, in the beginning, when their child is taken, they're not thinking, I don't want my kid to go with another family member, because they're automatically thinking long term. And so they're just not able to really answer the question at that point in time the way that it needs to be answered. And I find that when I come into a case, the first thing I ask my clients is, do you have other placement options, friends, family, aunts, uncles, brothers, sister, grandma, anybody? And I get the information when it's been available to those within the system the entire time. And I was talking with you earlier, Raul. I was thinking it would probably be very helpful if at every court hearing, the court actually made a detailed inquiry into potential caregivers and relatives at every single hearing so that it would come up often, not so that these relatives would find out later in the process when it's potentially too late. And we can talk about some of the restrictions that impact how it can be too late, but it's all about timing.
And
I like that idea of starting early with the anticipation, should these fail-safes fail, that we have a plan in place that all parties are on board with. They're not getting a phone call at 1 a.m., your name was given to us by so-and-so, can you come get your nieces and nephews or whatever they may be to you.
And it's not always that simple.
No, I'm sure, but even so,
what were you
in the
going to
last
say?
moment.
No, I was gonna say if there is a relative, right, that is reached out at the beginning of the process, and there is a shelter hearing, could they attend the shelter hearing and possibly take the child in temporarily?
Yes. Yes.
And in those cases where, like you mentioned, relatives are not made aware, then what would normally happen to the child?
Can I ask you to hold that thought for a second?
Yes, go for it.
We have to go to a quick commercial. We got caught up in the conversation.
Okay.
We'll be right back.
Finding the right home loan should feel like the last piece of a puzzle. Here in Vero, one name stands out for experience you can trust. Gina Melton at Riverside Mortgage Solutions.
With over 16 years of local expertise, I'm not just a loan originator, I'm your neighbor. Don't settle for an out-of-town lender. Talk to me at 772-205-8880. Call me, Gina Melton, with Riverside Mortgage Solutions.
Riverside Mortgage Solutions is an equal housing lender. NMLS 1712816 and NMLS 87788.
At lunchtime, enjoy a southern home-cooked meal paired with the best sweet tea in town at Marsh Landing. You'll love our daily lunch specials like chicken and dumplings every Thursday, or one of our juicy half-pound burgers. Experience old Florida cuisine at Marsh Landing in Fellsmere.
Tired of pool chores draining your weekend? Deja Blue Pool Service provides the expert skimming and chemical balancing you need for a crystal clear paradise. For Vero's most reliable professional care, Google Deja Blue Pool Service. Keep it clean, keep it blue.
Welcome to Riverside Theater's Comedy Zone, where the comedy is wild, untamed, and downright hilarious. Hit the zone this Friday and Saturday night at 6:30 and 8:30 for the Treasure Coast's best live stand-up comedy show, featuring nationally recognized comedians with cabaret-style seating and food and drink table service. Buy tickets at riversidetheater.com and get ready for a night of non-stop laughs.
All right, we're back. Commercials are always painless, but we are extremely grateful for them. And I want to give a shout out to our show sponsor, Dill Evans and Rhoda back in Sebastian. They do a lot of focus on elder law and trust and real estate law, and they have been serving our community for over 30 years. So if you have a need, please don't hesitate. Reach out to them, get a consultation, find out what you got to find out so that you're on top of things. So back to our conversation. Raul and Susan were just kind of delving into a question, and I had to interrupt. I'm sorry. And we are back. And so we're going to go ahead and let you go ahead and ask again, and then I'll let Susan pick back up.
So the question was, when relatives are not involved in the shelter hearing, where is the child placed?
The court has to temporarily place a child somewhere, and that's why foster parents and the entire foster care system exists, because it's supposed to be for emergency placements. And often, in my opinion, they're meant to be temporary placements as well. And so in the interim, and it does happen very frequently, that a child will go to foster care for a few days until either another foster home with a sibling can be found and they can be paired together, or they'll be placed there for a few days while the background checks and the home studies are being completed on the relatives, because it's not automatic just because you're a relative. And that was something that I was going to try to talk to you about, because as much as you would assume that relatives would be automatically considered, and I did want to make this distinction as well, when we spoke of adoptions before the last time I was here, if you are a relative within a third degree of sanguinity, which means aunt, uncle, grandma, grandpa, you know this better than I do. If you're within that familiar line, then no home study is required. It's the quickest, easiest adoption. But in dependency, because the state is now acting as the parent, they have to make sure that the child is not going into a situation potentially worse than what they were just taken from. So they have to do home studies. They have to determine whether or not the family can afford the children, whether or not the family can handle the children's needs. Sometimes there's children with special needs. There's all kinds of considerations. So it's not automatic, and that's also what creates the delay in the process. And I know you didn't ask another question, but I think this is a good segue. In 2023, prior to that, all of my experience in dependency, termination of parental rights cases are supposed to happen very quickly once a TPR is filed. And I can go backwards and tell you what that would take. But once it's filed, in 2023, they put into the statute a time limit that anyone who wants to jump in to adopt, that's a relative or anybody else that thinks that they should adopt, has to come in within 30 days of the filing of the termination of parental rights petition. But what is really concerning about this is that twofold. Number one, dependency, child abuse, highly, highly confidential. I can't even call the courthouse and say, hey, I had a consult come in. This is the case number. Can you tell me when the next court hearing is? They give no information. So how does a family member who hasn't had contact with the parents for a few months, they live across the coast or whatever, how do they become aware that the situation has occurred? They can't jump in on the 11th hour anymore. It was specifically designed that if and I said before there was a backlog, for example, in St. Lucie County, where termination of parental rights cases may not go to hearing for a final trial until 6 months, a year after the petition's been filed. Now, within 30 days of the filing, if that other family member or interested party does not jump in and do their filings and put their hat in the ring, they're barred by time. And if you don't know, how can you? That has become a very frustrating part of my practice because I find willing, capable, loving family members who miss the deadline. And there's nothing that you can do. You cannot intervene after that point.
Seems a little bit, I mean, obviously I don't know this section of the law, but it seems a little bit restrictive because, you know, number one, we're, I would say, depleting the available homes for those who really need it in a foster situation. Because if we're going to allow these children to remain with the foster parent, what happens with the next child?
That's a very good point.
Because the family members could come in and take the burden off of the system.
Right.
But it looks like they're not going to be able to because of this new deadline.
Right. And those are competing concerns for everybody involved, right? So you have that, which you just mentioned, but at the same time, you have a competing attachment and a bond that is continuing to grow with whatever the replacement caregiver or whoever that person is, whether it's a foster parent or a grandparent, right? So for example, what I was mentioning earlier as the twofold is that they also changed the statute that if a foster parent or any other caregiver has a child in their custody as a placement for a period of 9 months, they are then able to have party status. And then they are also able, with a presumption in their favor, that the child should remain with them, regardless of who they're trying to move the child to, except for a parent, right? Reunification is a little bit different, but if you're going to move the child from that foster parent or that other caregiver and it's been 9 months, it's almost a losing battle as well, because now they're attached and it's not what's in the best interest of the child because they're young children and they form these attachments. And it's just, in my opinion, it's another removal. Every time a child is either taken from a parent, taken from foster care, put in another placement, that placement has an issue, gets moved to another one, that child has been re-traumatized that many times.
And it follows them to every destination.
And it does. And I believe that 9 months is necessary, but it's a two-edged sword in the situation where it makes it that much more difficult for a willing and able and totally acceptable family member to keep this child within the family system where a child, in my opinion, truly belongs.
Right. There should be some type of not exception, but there should be some type of inclusion at the inclusion of these family members at the beginning of the case so it doesn't get to the 9 months. So that they can throw their name in their hat.
You would think so, and that's why I was suggesting that maybe at every hearing there's an inquiry of these available parents or alternative caregivers, you know. But at the same time, until the rights of the biological parents are terminated, they still have the constitutional rights to have input on where their children are placed, which is, and this leads me to another, there's something called an intervention. It's called an intervention adoption. Do you mind if I go into that?
Sure.
With the intervention adoption, just because you're a relative, you can't file to intervene. You have to have one of the biological parents signing a consent designating you as the person that they would like to adopt. Then you file your intervention. What also happens with that intervention that's statutorily required to be attached to that pleading is an approved home study. Where do they get the home study from? As the department doesn't know about them. They have to do a private home study that starts at $5,000. Is the department going to accept that home study? By the time that they have to file within the 30 days to intervene from the TPR, they have to have all that done. And it's very difficult.
So I'm hearing a lot of being preemptive is really important.
It is.
This process moves faster, and there's been recent changes that don't offer the family the time frame and grace that once existed if they were inclined.
Yes.
And obviously the state's whole goal, as you mentioned earlier, would be to keep individuals with their bloodlines, if possible, their families, somebody that recognizes and that they have a connection to. But timing, which I've heard repeatedly from you, is shifting, and now it's more important than ever, isn't it?
Yes. And I believe the legislature thinks that the timing and the time constraints they've put in are protective of the child. And I see that, and I recognize that.
I can see both sides of it.
But it is a two-sided coin. There is also the inability for the child to then be with family. And we all know how grandparents and cousins and uncles and all of those in our extended family are important to the family system. But then again, sometimes that's not possible.
Let me ask, once the case gets started to remove the child, when is the petition for termination of parental rights filed normally? Right at the beginning, 2 or 3 months out?
I'll tell you. So in general, there are expedited termination of parental rights cases. Those are based on egregious abuse. Think torture, think, sexual abuse. That's, very bad. Think people who have had multiple removals in the past. And the department decides right when they come in, we're not offering these parents a chance for reunification or a case plan. And then in the immediate filing, they file for termination of parental rights. That scenario cuts what we've been talking about.
There's almost no chance.
There's no chance at all. But on the converse, because not very many are filed expedited, the timing is usually they get a case plan. If they're during the case plan process, it can only be up to 1 year for permanency. The case plan goals are generally 9 months or 6 months. If they are not complying to the point where they are not likely to be reunified, the department has the option to then file a termination of parental rights. But in general, it's a material breach of the contract, which is the case plan between the parents and the state to do services and tasks within a certain time frame.
So the idea would be, if there is someone in the situation, the normal time frame would be before the 6-month period, start talking to relatives, start getting them involved so that they have that private study completed. So by the time that the petition for removal is actually set in place, there's at least a second or third option there ready to go.
I love what you said too, because that is actually best with the 9-month
so that 6-month period, because then once that's determined, you only have 30 days if you're going to be one way or the other. So having those preemptive conversations, we're covering a lot of information. Our time is short, Susan. I want to dive deeper into, the AARC and the Adoption Application Review Committee that exists that then helps that whole process move forward in the court structure, sometimes in reference to the families and sometimes outside adopters. I wish we had all day for this. I find it fascinating. I've told you before, I have many loved ones in my circle that have been adopted and have adopted. I think this is valuable information, and thank you for joining us today. I wish we could have had a bigger close. Maybe we need a part 3. It definitely sounds like it.
Yes, ma'am.
Thank you for joining us
You're
today.
welcome.
We appreciate
Thank you
your
so
time.
much.
We'll see you in 2 weeks.